order the Sacramento County Board of Supervisors afternoon session for November 6, 2018. Madam Clerk, please take the roll.
Supervisors Frost.
Here.
Kennedy.
Here.
Natoli.
Here.
Cerna.
Here.
Peters.
Here.
And you have a quorum. Item 44, I need a motion to drop the ordinance to amend the Sacramento County zoning code related to Community Planning Advisory Council's appeal fee waiver.
So moved.
Second.
Please vote.
Unanimous vote. Item 45, resolutions adopting the consolidated planning application fee schedule and the parking lot shade tree replacement account fee schedule.
Good afternoon, members of the board. Leanne Moffett, your County Planning Director. I am here to give a presentation, but I do not have a PowerPoint.
Yay! You get a gold
There's
star.
nothing graphic in here. So I am going to go over the materials that are in the board report with regard to the fee package that we have in front of you. I'm going to start off by talking about the design review fees. So we have long had a structure in place for non-discretionary design review that has major, minor, and incidental design review fees. But for discretionary entitlements, we only had one fee, which was a higher cost fee of a little over $3,000. And over time, we've discovered that just because something's a discretionary entitlement doesn't mean that it necessarily warrants that fee. So instead, we want to move it to that major, minor, and incidental so that certain projects can avail themselves of the lower fees. And then we also have a fee for projects that are reviewed by the regional parks when there's a parkway item, and that fee remains the same. It just shifts some of the money over to regional parks because they're taking the lead on the review. So the fee amount is the same, it's just who gets the fee. The next category of items we have are a number of cleanups. A lot of these are items that don't come up very often, and after we adopted the last fee schedule, we in some cases had an item come up and realized we didn't have a fee for it. So there were 3 items that on very rare occasion are elevated to the board. Those are abandonments, boundary line adjustments, and special development permits that we just lacked board level fees for, so it recreates those that used to exist. We also missed having a line item for zoning administrator special development permits. We are asking for an increase for the sheriff's participation in the alcohol PCN process of $10, which is a fairly minor adjustment. And then we're adding footnotes pursuant to prior board direction about not charging a fee for certain urban ag items, and so we'll get that notation noted on the fee schedule. Then we have 3 categories of new fees. The first is public health review. There is a more detailed write-up in attachment 1 to your board report, but back when the county adopted the 2015 zoning code, we incorporated into that the importance of public health in the built environment with active design strategies. And so since that time, public health has been participating in the review of a number of relevant entitlements, and they now sit on the county's project review committee. So this fee allows them to recover some amount of money for that. It applies to 10 entitlement types, so it doesn't apply to much of what we do, or a lot of the entitlements don't have this fee. And the fee range is between $88 and $264, which is commensurate with other departments and agencies' reviews. The second new fee is for the survey section. So we are now using survey section to provide expertise on a number of applications to review site plans, boundary line determinations, and particularly whether parcels were originally created in compliance with the Subdivision Map Act, because there have been some historical problems with property owners pulling parcel numbers or creating deeds and creating parcels that aren't necessarily buildable outside of the Map Act. So this allows them to raise issues earlier in the process. We're finding that that helps resolve things by identifying problems right up front so that they can be addressed, and we believe will save time and money in the long run. And then the third fee is for replacement parking lot shade trees. This is called for in the zoning code, but we have never established a fee. And so that what this is used to do is to discourage property owners from removing healthy, mature, required shade trees in parking lots like commercial and industrial areas. So it does not apply if a property owner comes in and gets a tree permit, Like if you have a unhealthy tree, you can certainly get a permit to remove that tree. But if someone simply comes in and cuts down their mature required shade trees, then this fee is based on the wholesale value of the tree when you replace it. So presumably they may have a mature tree, they're going to replace it with a small 15-gallon tree, and so the fee is based on the wholesale nursery value of the new small tree versus the larger tree that it would take to replace that. Now, if they had a small tree to begin with and they replaced it with a small tree, there wouldn't be a fee. We will also be working with the board in the future on the use of those funds, and it will be for trees and landscaping items. And that concludes the staff presentation.
Questions? Mr. Natoli?
Thank you, Madam Chair. Leanne, I know we dropped a portion on already in the previous item on the as related to the CPACs, but I want to go back to the appeal fees, and I know that I've raised this in past years, and I'm going to continue to make the point. I wanted to get some information because it didn't show a side-by-side. On the updated fees, as I understand the chart on page 2 of the chart here, that in order for someone to get a matter before the Board of Supervisors is $4,000, whether it came from the delegated authority to the BZA or from the Planning Commission. And I know that in a hearing earlier this year, we heard from some folks who said, and maybe rightfully so, I don't know that we did any comparison, but that our appeal fees, in order to get before your elected officials, are the highest, just about the highest anywhere in the state. I don't know whether that's true or not, and I'm not asking necessarily to validate that or not today, but it just goes back to a basic premise here. I get it. We don't want, just, superfluous appeals coming for this body. But on the other hand, the right of people to petition and to appeal to their elected leaders, not to the appointed planning commission or to, professional staff, and to say you got to put $4,000 down on the line. And I recognize that some of these come through with planning entitlements, and they have legal representation, they have engineering representation. I get it. But if you're going to level the playing field, it seems to me that the citizenry of this county and any county or community ought to be able to get to their elected officials for less than $4,000. And I know there's staff time. It's not for you to necessarily, there's like a whole calculation behind this. But this is the first time we've had a chance to talk about this for a few years. And I'm going to raise the issue because I feel strongly about it. I just think that, a part of general government and good government ought to reflect the ability, again, maybe with some cost nexus, to get to this body to have us make a determination on a matter, big or small, shouldn't be just a $4,000 bill. To me, that seems like a heck of a lot of money, and we've had some citizen appeals and things over the years where that becomes a real barrier, and people just go away. They go away either mad or disappointed, and maybe not getting the hearing that they should have had before this body. And so we really haven't taken this on head on. We've had some discussion under prior administration about some of the other fees. And again, I'm not trying to put you as planning director in the middle of this, but I wanted to put it out here because this is the opportunity to talk about it. This has been a long time in the works in one form or the other. And so, I don't know, Nav, I know I've talked to you about this, and I've expressed it in hearings in past years, not any time recent, but it seems to me there's an equity factor here when it comes to the recovery of costs, which, for a special project, you say, well, that shouldn't be borne by the general population. But in years past, going back many years ago now, general government was under this umbrella where we had the funds to support it. We went to a fee schedule that reflected time and cost recovery, which makes sense for entitlements and so forth. But in order to get before this body on a matter of an appeal, I don't think $4,000 is an appropriate amount of money. I mean, I don't know what is. There should be some charge. It shouldn't be just free. I get that because nothing's free. It gets borne by somebody. But I don't think that the applicants should necessarily have to bear that cost.
So a couple of suggestions on that. I know that there's been a desire to have this conversation. That's what we're here today.
For a while.
What you see in front of you is a full cost recovery model that planning worked, and that's what the cost that they came back with. So the policy question from the board is that if there's a desire not to charge up to $4,000, how much do you want fee to support? How much would it be out of general fund? I think that's the essence of the question.
So, and we have done some research, and I think we are prepared to bring that back to the board in the relatively near future. And we just had some other items we needed to work out first, and then we are prepared to bring that for discussion
I'm fine
forward.
having discussion whenever, but
I just want to make sure that before we go embark on that to come back, is that we do have the policy discussion. There is interest from board for us to come back with an agendized item on that. So we do have some material, but I think the conversation, Supervisor Natoli, from what I understand, is that you wanted to have with your colleagues is there interest on that, and then we can craft something and bring it back to you.
yeah, give us some options, take a look at some comparisons. Again, we don't have to be the lowest, and we certainly don't need to be the highest. And again, but I don't want to be a block to people exercising their right, and rather than getting 2 or 3 minutes at the podium, anybody come here off agenda, that's not the same. It's, when you're into, and particularly entitlements that have a very high degree of permanence to them, and obviously there's legalities go behind, land use entitlements. But it just seems to me on these matters, as complicated as things are in our society, people still ought to be able to come before their electeds without having to put, four $1,000 bills down on the table and say, I get my day in court, my day before the board. So, yeah. So I'd like to have that conversation. I don't know how to just feel about it. Again, we're not going to determine it today, but I wanted to raise the issue in the context.
Yeah, we fully intend to bring that back before the board as a separate
Actually,
item.
Leanne, I'm asking a little bit different question. I know you want to
Okay.
bring
The
it
other
back.
board members,
Yeah.
they-
I just want to make sure I'm just looking at
Not
other
just
board
hearing from me.
members. Are you all comfortable with us bringing that back to have the discussion about discounting the fees? That's what I'm seeking some guidance on.
Over and above the appeal fee, or just the appeal fee?
Just the appeal fee.
No, I'm supportive of.
Yeah, just,
having
it's
to
the
have a-
appeal fee. It's the
Yeah, have
appeal
a
fee.
focused
Yeah.
discussion on that particular fee, yeah.
And to be more specific, I think I've asked for it before, if we could have information on what other jurisdictions, because whenever we have this issue come before us, people always claim that ours are so much higher than everybody else's, and I really don't know.
I don't need, yeah.
Okay. We'll bring it back.
Mr. Cerny, did you still wish to speak?
Yes, please. So, of the fees, Leanne, that you're asking the board to consider today, how many, if any at all, will or could affect the provision of affordable housing in its various forms?
For the most part, I would say these are not directly related to affordable housing. The change to design review could be a minor decrease, but I don't think most new affordable housing projects would necessarily be a minor sign or whatever, right? They'd probably be a major construction, so
Sure.
I don't think there's any change there. The public health review could be a very minor increase, which would probably be a very small percentage of the overall costs. I don't know how much the survey section work would tend to relate to affordable housing. I think not,
Okay.
but
Well, I know that this is fairly specific today, what you're asking us to consider, but in light of especially the discussion that was had, I believe, last week or the week prior at the Sacramento City Council on impact fees, development fees that do affect the provision of affordable housing in that jurisdiction, I would like us to consider coming back sometime in the first quarter with a focused discussion on kind of the universe of fees, the entirety of our fee schedules that are affecting affordable housing, provision of affordable housing, to understand whether or not there's room for or need for change relative to that suite of fees, in the interest of obviously reducing the cost for something that I think we can all agree is much needed here in this county and elsewhere. I don't know that we've actually had that focused conversation here before, especially given the fact that this crisis continues to mount the way it does.
Yeah, it's been almost 10 years. So when you mean fees, it's inclusive of impact fees, any other kind of fees we charge, the whole package?
Yeah, and I think, having an honest discussion about trade-offs, right? Whether or not it be a fee that is intended by design to be a complete cost recovery fee. And to Mr. Gill's point made earlier, if it was the will of the board, for instance, that we wanted to consider a fee reduction in one area, well, what does that mean in terms of, the impact to the general fund? And I'm not going to presuppose what the disposition is of my colleagues or the entire board here, but I do think, given the fact that we have Prop 10 on the ballot, we have Props 1 and 2, we have just growing interest out in our various constituencies about the dearth of affordable housing. This is one way that we do have something in our immediate control. And we just haven't had that conversation. So I'm not asking it for tomorrow, because I know we have a lot that stacks up at the end of the calendar year, but I think it's fair to say perhaps by the middle of the end of the first quarter of next year, if that could be agendized for a public workshop or a discussion by this board, I think it's time that we do that.
Okay, we'll do that.
Thanks.
Yeah, I have a question about the tree fees. In reading this, I'm trying to figure out are you charging the fee for the size of the tree that's pulled out or the size of the tree that's being put in?
It's the delta between the two. It's the difference between the two. So say you took out the equivalent of a 36-inch box tree, and you're going to replace it with a 15-gallon tree, so a much smaller tree, you're going to have to pay a $375 fee because you're replacing it with a smaller tree.
It's a tree maturity fee, right?
Great. Basically, that's what it is.
I asked the same thing, Susan. That chart works horizontally and vertically.
Yeah, it's making me cross my eyes. I don't think this is very easy to understand at all.
Okay.
I mean, it looks like you're penalizing someone for putting in larger trees. I don't...
You're actually penalizing them for putting in a smaller tree. If they replace it with the same size tree, then they're essentially, so if they had the equivalent to a 24-inch box-sized tree and they replace it with a 24-inch box-sized tree, they pay no fee.
Okay.
But if they take out a much larger tree and plant it with a smaller tree, then they have to pay
So
for
this
that
presupposes that someone will tell the county that they're taking out a tree.
This would be...
They do that?
Sometimes we catch people for we get a complaint. What happened to all the mature trees in X's parking lot? And
Well, how will you know what size those trees were, whether they were diseased or...
well, if they didn't come to us for a tree permit, then we presume that they're healthy, and we typically do have visual evidence of generally what size tree it was. So we can...
Is this for commercial properties, not residential?
Yes, it's commercial. It's required parking lots, which would typically be commercial or industrial, predominantly commercial.
So in the regulations, when you're building out a commercial building and putting in the parking lot, does it say in there that you have to get permission from the county to take out a tree?
It is a requirement of the zoning code, yes, to maintain your landscaping. So yes, they are informed when they come in that they are required landscaping and that they are required to maintain it.
Well, maintaining it doesn't mean they're going to call you and say, I have to replace the trees. I don't know, I don't get I mean, I'd like to see the trees replaced.
Yes,
Love my trees.
yes.
But I don't think this is very practical. I mean,
we probably don't catch every tree that's taken down, but certainly when you have a shopping center area where someone has come in and basically killed the trees for no good reason, simply because they want their signage more visible, then we do view that as a problem, and we do want a mechanism to be able to prevent them from removing, trees that have been growing for 20 years, providing valuable shade, and yeah.
I think this is going to be very difficult to enforce. I don't get it.
Okay.
Madam Chair, maybe offer a suggestion here, again, without adding to paperwork and so forth, but particularly going forward on projects. I mean, obviously, you got a lot of properties that come through, and there's been development standards that have been in place for a good deal of time, certainly parking lot shading, but just generally landscaping. It seemed to me that there ought to be a file maintained, digitally of, and maybe you do that. Maybe that's all put together. But just what was submitted, so you know what trees went in, so there's no dispute. Now, to the chair's point, that after 15 or 20 years, somebody cuts them down. Then how you make that calculation is probably going to be more an art than it is a science, and it might be open to dispute as far as I know. But I think having some backdrop so that you know what actually went in, either when you file your final building permit or your final development plan or things get signed off, that there's a point in time that there's a electronic memory of that, and then you've got you can say what was on plans, but even when you get things called out on plans, you don't always put in 15-gallon trees or boxes, because as long as they get the landscaping in, we're not doing all that check. And so, I mean, you could have a major discrepancy, albeit you're going to have growth if they're properly maintained. And so I think that's what you're trying to get to here. I think the concept behind it is to certainly, not penalize folks that aren't behaving badly, but if there are those that, again, for whatever reason, decide they're going to, and maybe there ought to be some acknowledgement. Maybe that's the other thing, is that it'd be very clear on plans or on approval that, your landscape plan, your tree planting plan, it's a matter of record, and that, in the event that you might be, and there are subsequent owners and corporations buy the centers and so forth. But I think to provide a little bit of clarity, otherwise you just put a fee in and say we approved it in 2018, and, 2030 they decide they're going to take the forest out and put something else in, and they get a county permit, and then they're going to get a bill for God knows how many thousands of dollars. It may not be anybody in this room's problem at that point in time, but somebody's going to have to deal with it. So it might be, I think, to get a little thought about the mechanics of it. I think Susan makes a good point. I mean, it would be difficult to police or enforce in some specific cases, but I think generally you could maybe do something, Leanne, that wouldn't be burdensome. I just offered it as a suggestion. I don't know. I just as the conversation.
And so is there any discretion in this? There's like olive trees, when they get put in, they're old when they go in, and they're big. And if it's there for another 20 years and getting bigger, you couldn't find a tree that size to transplant. And so why are you penalized if it's diseased?
If it's diseased, and they can demonstrate that, then we're happy to issue them a tree permit.
Okay, then let's talk about that shopping center that you and I have talked about on Arden and Morse there, that recently redid their parking lot and reconfigured it. Did they call the county and say they were taking trees out?
I need to check and see whether they came in. I think they did come back in for design review, and I think that may have been permitted. So in that case, that would be okay, because they came back in to do improvements, as opposed to the circumstance where we see where someone just decides to remove the trees simply because they typically want the signage to be more visible. So if they come in...
I can think of another commercial center where it was full of really old olive trees. Mm-hmm. And, and the management company had all the trees cut down. No tree replacement. 0. And all the tenants are fussing about it. And it's an old center, how would they know? I mean, it's probably a 40-year-old building and parking lot, maybe 50 years old.
So you're concerned about information going out to property owners so that they know that they're required to maintain their landscaping.
Right.
Okay, so I think that's something we can work on. We have wanted to set up this fund so that we have the ability, we've had conversations about trying to incentivize the plantings of trees along certain corridors or in other areas that lack landscaping, and trying to take this pot of money and using it to incentivize improvements throughout the county. So I think we see it as a fair trade-off, but I understand your issue about notification, so maybe we can go back and think about how to do some outreach. We've certainly done outreach to commercial property owners in the past, and maybe we need to just remind everybody of that obligation.
think you got to do something like that, because I mean, I could sit here all day and tell you about various commercial properties that are older, and I don't think anybody would know.
I think based on the feedback we're getting, I think this piece, why don't you give it back to us for us to do a little bit more work on it? What kind of notification and enforcement? That's what I'm hearing is notification and enforcement
Yeah.
are two areas of concern. We'll work with planning to come back with a package that has that in there.
Okay, because I think it could be very uneven, too. You know, one owner gets nailed and the other doesn't, and thank you. Okay. Any other comments on this? So, okay, I need to open the public hearing. Is there anyone here who wishes to speak on this item? Seeing none, I'll close the public hearing. And you're planning to come back on the appeal fees. That's already in the staff report, so do we need any additional comment on that? Okay, so then I just need, and we need a motion that says we'll come back with the tree piece.
Yes, so we luckily did have the split into two resolutions. So staff recommendation number 2 has to do with the rest of the fee schedule, which appears to be fine. And staff recommendation 3 has to do with the parking lot shade tree replacement fee. So I think we're just not, you just won't act on that.
We're just going to deal with
item.
number 2.
Just do number 2.
Okay, so I need a motion for item.
Second, and that's absent the appeal fee changes thus far.
Please vote.
Yep.
Unanimous vote.
Thank you.
Item 46 is the George Hills Annual Report presentation.
Good afternoon, Madam Chair, members of the board.
Hello.
When I put these reports together, I always am a little nervous what the bottom line number is going to look like. We certainly look at things monthly to see where we are, but then when you have to add it all together, you're really not sure what's going to show up. And so this is one of those years that fortunately the overall costs went down significantly. And you know, that's a good thing, and it's fun to stand up here and talk about that. But on the other hand, I think it creates a benchmark for, can you replicate that next year and make sure it doesn't go up? And unfortunately, claims are such to where it's not possible. But anyway, let's take a look at the slides. Exhibit A shows a breakdown of the total program costs. So that's everything. That's the adjusting fees, all the defense fees and costs, claim payments, miscellaneous expenses. And again, it's really just meant to show the percentages of all those when looking at them individually. And as you can see, the dollar amounts can change significantly from year to year, but the percentages of the total seem to pretty much stay the same. I mean, you can look at GHC fees anywhere from 4 to 6% every year. The attorney fees are somewhere between 31 and 39, claim fees 55 to 65. So again, the percentages stay fairly stagnant or the same, but dollar amounts can change significantly. Next slide, please. Or is that me?
I think you have to have a little gizmo down there.
All right. There we go. Exhibit B shows dollars spent per category and the increase or decrease when compared to the previous year. So as you can see, as I was talking about originally, the numbers have gone down substantially, and specifically in the two most important categories, and that being what we pay our defense lawyers as well as the claim payments that are made every year. The amount of dollars spent in 2017-18 totaled $11,710,403, which is in stark contrast to last year, which was $17,416,163. So again, this decrease of 12% in the litigation cost category was due to several large litigated files being closed. The 42% decrease in claim payments was due to the decrease in large value cases in the overall claims inventory. It's not to say there aren't large cases that are still open. We talked about those this morning, and they're still active, but the number of larger exposure cases, the total overall, have decreased. And, you know, for paying $6,818,221, 8 cases made up 79% of that total. There was one case that settled for $1,000,003. There was another one that settled for 1.5 and thereabouts. 6 others settled for 2.5 million, and then all the rest of the settlements were relatively small. So again, it's always the large cases that are going to drive that number. And in this year, it was only 8 that drove 79% of those payments. Exhibit C shows an increase in the number of new lawsuits received. It happened many years going back in the early 2000s that we would get 100 plus new lawsuits a year. And those days are long gone. We're down to double digits, which is a good thing. There was an increase of 13 from last year to this year. In looking at the number of new lawsuits received, the majority continued to be in the area of employment practices liability, which is your discrimination, harassment, that sort of thing, as well as law enforcement related incidents. And again, the law enforcement related incidents are going to continue. It's not just here, it's everywhere. We all know that, and so it's not a surprise that the highest category is always law enforcement, and will continue to be that way. Exhibit D shows the actual dollars paid to the 5 firms that do work for the county. Again, it's a nice decrease in light of the large amount spent during the 2 previous years. There has been a reduction of, as I said, larger exposure cases, which is the main reason for the decrease. There is a difference, which you won't necessarily see. It's the difference between the amount paid to the defense counsel, which is $4,092,107. The actual amount of costs and fees that were paid to all defense counsel was actually $4.8 million, and these additional fees, which aren't paid to our traditional defense firms, it's where we have to hire a separate law firm because there's a conflict within our employees versus the county. There may be other reasons for conflict, but these are pretty much one and done cases that have to be assigned to outside counsel. Exhibit E shows the lawsuits closed without a payment and the number of litigated cases where claim payments were made. It's difficult to actively try and control cases where a specific overall result can be achieved, meaning closing more without a payment than with a payment being made. But the goal is obviously to defend every case and pay, as little as you can, but there's plenty of cases where it's a case of liability. It's just a matter of how much you're going to pay. So we always shoot for more than 50%, but as I said earlier, from year to year, it's hard to control claims, what are coming in the door, the types of claims. So while 50% I think is a good number, we'd much rather see 50, the 57%, or even 60% numbers, which we've had in the past. Exhibit F shows lawsuits by department. As I mentioned earlier, the Sheriff's Department had the largest percentage, 46%. Again, similar nature to all previous years, and again, there would be no reason to anticipate a change going forward. Exhibit G displays the type of lawsuits filed. So we have other personal injury cases, which include harassment, discrimination, civil rights cases where no bodily injury was sustained. Again, the largest number in this category, 51% of the total, being non-bodily injury type cases. The other bodily injury cases was second with 32% of the total. Those can be as a result of auto accidents, trips and falls, many law enforcement activities, as well as other kind of unusual things that can happen that can injure somebody on county property or by county property. Exhibit 8 shows a 15-year accounting of all new claims handled by George Hill's company. The decrease from 16-17 to 17-18, I would certainly consider negligible. It's 667 down to 645. If you look back in history, there were a lot more county employees, and there were a lot more claims going back in the early 2000s, and we handled additional work other than what we do now for the county, mostly sewer-type losses, which are handled by somebody else, which is why the numbers were so much higher previously than what they are now. So that's the end of the PowerPoint. You will find in your packet the scorecards, if you will, of all of our defense counsel and how they did this last year when looking at all their closing files. In almost all cases, and I didn't bring it with me, but the payments are lower than, or can be lower than the amount spent to defend them. Again, that's not unusual for this county or anywhere else. It all depends on the type of case there is. So, questions?
Okay. Mr. Natoli.
Yeah, just very quickly, just to your last point, Randy, because I just was curious on, I guess, page 15 of the, I just not so much randomly, but there was one example there where the cost to defend was, fees and costs were almost $104,000, and the claim payment was $4,700, $4,685. And I mean, all that tells us, doesn't tell us what the actual, cause of action.
Type case, right?
Yeah, type case, but also what they were asking for. So obviously, they may have been asking for $1 million, and we settled for $4,600, and it cost us $100,000 to do that. But maybe for purposes in annual reports, maybe in those cases, if nothing else, give us some idea of kind of so it shows that actually in the county's defense with the ultimate settlement that. It was the cost of doing business in order to defend and or to investigate or whatever.
I did that for a number of years, and then I stopped doing it, and I only show these. So I will go back to the old way to give you more information.
Okay.
And there wasn't any particular reason why I stopped doing it. It was just, this was frankly easier to do because unfortunately all these have to be calculated by hand. There's nothing in the computer that allows me to do this. So I'll go back to the way I was doing it.
And there wasn't too many of them. So I mean, I don't, some of these are, obviously it's just the contrary that you spent a little less. Yeah, but at any rate, okay, thank you.
Easily done.
Yeah, thank you. I would like to ask the county executive, when you get this report, do you and others in your administration study where the claims are coming from and whether there are policies, procedures, et cetera, that need to be changed to potentially lessen the amount of money paid out?
Yes, we have the assistant and the deputy county execs get the report on a monthly basis, and they meet to review what's causing, what kind of policy changes we need to make, and recommendations back to me. So we do have a system set up for that.
Have you seen any positive, any lowering of the amount of claims or the number of claims or the amount of the suit?
Not at this moment. There's some policy changes that we have looked at. As reported, some of the numbers that are shifting back and forth are fairly negligible, going up and down. The dollar amount payment is something that we do pay pretty close attention to, but some of that is out of our control too if it gets in front of a judge or a jury. But what we're really looking for is that the policies we have in place, are they applicable? Are they still something that we can manage with? And if we got to make changes to it, what do we need to do to it? And particularly if a particular department ends up getting more claims than previous months, that's a discussion with the corresponding agency administrator and department head on what's causing it to go up.
Okay, thank you.
The one thing that has decreased significantly over the years, which are road type cases, dangerous condition, that sort of thing, they've decreased precipitously over the last 4 or 5 years. And as I understand it, there's more attention to maintenance. But we see such a decrease in those types of cases, which again, those can create the deaths when you have cars crashing into each other, that sort of thing, because of a dangerous road condition. We see very few of those nowadays. So,
okay. Mr. Cerna?
Thank you. Have you ever prepared these figures by choosing some select counties of similar size so that we get an idea of the trend in claims, either up or down, on a either per capita basis for the county's population or on a per capita basis based on size of organization? And
I have not.
And how do we look?
Right. I have not. Risk management has looked at that several times over the last, I want to say 5 or 6 years when Steve Page was here, and he would look at similar size Riverside County. There were some other counties, and they were similar, but I can't tell you similar such a general term. I can't answer that for you. I don't know whether we have that. We certainly could get that kind of documentation, and
Mr.
I
Devine
guess
does
Dave's gonna address that.
Good afternoon, David Devine, Director of Personnel Services. Every year we do an actuarial study in terms of setting our rates for the next years, and they go through and they do a benchmarking against similar sized counties in terms of number of claims costs to see how we're tracking. So generally we're falling right in the median of those different agencies. There's nothing that's really, and we have to take into consideration too that most large agencies, like in terms of public safety here in the county, we have a large unincorporated area, where in most other counties that would be handled by a large city police department. So we have assumed more risk and more exposure right there.
Sure. No, I appreciate that. I think, though, in forthcoming years when we get this report, it would be helpful to have that as part of the presentation materials.
Right.
Because when you look at a chart like this, you may kind of squint and say, "Oh my gosh, trending looks good. Our claims are down." But I'd like to know, are claims down for other counties? Is it part of a trend that is trending with the rest of the state for some reason? Is it all relative to the size of the organization? Well, this alone will not tell me that. So I'd like to suggest that we begin to incorporate that in the years ahead when we get these reports.
Sure, we'll include that data.
Great, thank you.
Okay. Any additional questions from the board? And is there anyone from the public that wishes to speak to this report? Seeing none, this is a receive and file item. Thank you very much, Randy.
Thank you.
Next. Oh, 2:43.
Let's have a couple of minutes.
Okay, I want to do appointments.
Sure. Appointments, that would be item 48. You are continuing to December 4th, the Sacramento County Mental Health Board, continuing to December 11th, Cordova Community Planning Advisory Council, Developmental Disabilities Planning and Advisory Council, and the Local Child Care Planning and Development Council. Today, we have the Disability Advisory Commission,
Please continue to January 15th, 2019.
Equal Employment Opportunity Advisory Committee,
Please continue to December 4th.
Human Services Coordinating Council,
Continue to December 4th.
Mission Oaks Recreation and Park District,
Please continue to December 4th.
North Highlands Foothill Farms Community Planning Advisory Council,
Same answer.
and Sacramento County Alcohol and Drug Advisory Board.
Please nominate Aaron Cleveland to the technical representative seat and Ricky Townsend to the public representative seat, and the remainder to January 15th.
And then we have the Veterans Advisory Commission, Mr. Natoli.
Can you continue to tomorrow, please, November 7th?
Will do. That concludes your nominations.
And we're back on schedule.
All right. Item 47 is the 2018 Domestic Violence Death Review Team and Annual Report.
Good afternoon. This is my pleasure to be in front of the board again. Paul Dernberger with the DA's office for my wonderful boss, Anne Marie Schubert. I still chair the Domestic Violence Death Review Team, and as I believe this is our 19th presentation to the board. I wanted to thank the board for your continued support, not only for the Death Review Team, but also everything that's encompassed in the Domestic Violence Coordinating Council which includes the Domestic Violence Prevention Collaboration, the Family Justice Center, and all the collaborations that we try to do under family violence. I thought when I started today that I would begin talking about, because the death review team report is pretty dark most of the time. There is a light at the end of the tunnel when it comes to the other side of what the Domestic Violence Coordinating Council does, which is the Domestic Violence Prevention Collaboration and their support of the Family Justice Center. The Domestic Violence Prevention Collaboration, known as the DVPC, because everything in domestic violence has to have an acronym. I've come to know that that's true. They were formed by my sister's house and law enforcement and some other community groups getting together and saying we really need to have monthly discussions about how we can improve the way we do business with each other. Out of that became a lot of discussions, a lot of talks. The Family Justice Center was an idea that was proposed to them. They were very vocal in their support of it. And I'm very pleased to see, as you can see in the report that was given to you, that the Family Justice Center is not just open now, it's actually thriving. And I'm very happy with that. When we started out in July 2016, when it opened, the center was really just one room, a 2,500 square foot room. We had everyone packed in there together. We had lawyers, we had advocates, we had clients. It was not the best thing for attorney-client privilege situations, but everybody made do because we saw the big goal at the end. And now that we have phase 2 open, which is the collaborative center, we are open for business. We have now a really good separation between our lawyers and the advocates, and there's no issues with client privilege or privacy. We also have our community partners that are starting to move in because it took a while to get all of the infrastructure inside of the building ready to go. So my sister's house and the Lau Family Community Project is about to move into the center. We already have law enforcement moved in. We have the CPS interview team that's working with the center. And we also have our camp program, which I'm very happy to tell you has been expanded. We actually doubled it this year to 24 children. I actually am the Camp Hope coordinator in my off time. So I actually have what I consider to be the privilege of actually taking kids to camp every year. And I've become a true believer in dealing with children's adverse childhood experiences at an early age, trying to get that trauma training, not only for the people that are working at camp, but for the families that are dealing with kids that are dealing with trauma. I've seen little miracles every year that I do it. So I'm very happy with that. And before I go any further, I just want to thank you all for your support. We have our Family Justice Center gala on Friday night. Hope to see you all there. It should be a fun and entertaining evening. I did want to get into the actual report that we presented from the death review team. This year, we actually reviewed 6 cases, but only 5 of them were murders. One of them was an attempted murder. And I believe, in all the number of years I've been doing this, I remember coming to this board a number of years ago saying, I can't wait for the month where I can call up our death review team and say there is not a death that we have to review this month. And I'd never been able to make that call. I was actually able to make that call this year. Unfortunately, I can't say that means that we have fewer homicides trending down, because the way that the cases become available to us on the death review team is when the cases are finished with their court process. So there has to be a guilty verdict or a not guilty verdict, but the court case has to be closed before we can review it. So there were a number of cases that were still in the court system waiting to be adjudicated that we will be able to review when we start up next month. So I can't actually say that it means that we've had a great reduction in the number of homicides. Some of it is just that the court process has slowed down a little bit. And that was one of the issues that we addressed in our report and our findings, which I'll get to in a minute. You'll notice that And I also want to give my thanks to every member of our domestic violence death review team, because we gave them the option of saying, look, since we don't have a death, we could take the month off, or we could look at this attempted murder case, look at it, tell us if you think this would help us in being able to give positive recommendations to the board in our annual report. And they all said, yes, we think it would, so let's meet, let's do it. That shows some real dedication on the members of the team, and I really do thank every single one of them for their continued participation on the death review team. When you look at the 6 cases that we did review, one of the things that stuck out to the entire team were that there were 22 children involved in these 6 cases. Those are children that came either from the victim, from the abuser, or a combination thereof. So it kind of really, if you look at that number, it really tells you how the impact is of domestic violence. I had somebody once give the analogy of when you throw the rock into the middle of a still pond, the waves go all the way out, and they continue and continue. And in a lot of ways, domestic violence is very much like that. The waves don't just impact the victim and the abuser. There are families and children that are impacted by this. And those children and families need our help and need our support. You'll notice that the victims' ages were between the ages of 17 and 63, which I think is important because it tells you that teenagers, when they're involved in dating, can be the victim of domestic violence. It also tells you that people that have color hair that I have, gray, can also be the victims of domestic violence. It's not a kind of crime that only involves one race or one portion of our community or one age of our community. It really does run the gamut. Whenever we look at these cases, we're always looking for cases to see if we could document prior abuse. We found documented prior abuse in 4 of the 6 cases that we reviewed. 5 of the 6 cases, all of them being murders, were done, 5 of the cases were done by a gun or a firearm. And we found that alcohol and drugs, or a combination thereof, impacted 3 of the 6 cases. You will also notice that we break them down by race, just to show that every race is represented in this problem of domestic violence. We had a number of findings. One of the findings was that we repeatedly see unlawful gun possession by abusers who have previously been ordered by courts not to possess guns. And these orders can come from convictions where someone is ordered not to have a firearm for a certain number of years. It can come during the arrest procedure where they are given instructions by the court, or they're given bail or let out on their ordinate recognizance with orders that they're not supposed to possess any guns. It can also come from a restraining order being served on a perpetrator. And one of the lapses in the system that we found is that the system really doesn't have a way to determine if a abuser who is not supposed to have a firearm is actually following through with that order. It's really done on the honor system. And it's something that we believe that our county needs to address. If there could be a team that worked with probation. I know that there was a small team from the Elk Road Police Department a number of years ago that did have a team that was working on this. And if we could coordinate a team like that and connect it with especially the people that are going through the court system, because one of the lethality factors that has been documented is that when you're going through the court system, the likelihood of another more violent event goes up. We believe that this could actually save lives. The second finding that we have for the death review team is what I was addressing earlier, is about the number of actual cases. One of the things that I have been frustrated with, and a number of our team members have been frustrated with, is we've never been able to give the board an exact number of how many domestic violence deaths have happened annually in the county, because we don't review them as they come in. We wait until the judicial process is over. So we are proposing now that, coordinated with the coroner and every law enforcement agency in town, that by the 30th day of January, that the coroner report to the lead supervisor of the DA's office who runs the domestic violence death review team meeting most of the time, to report every domestic violence related death that they had in the county, and then also have every homicide sergeant in every law enforcement agency report that number so that we can verify that the numbers are accurate, and then include that number in our report so that not only our team but also you as a board will know if we are trending up or trending down in the number of domestic violence homicides that we have yearly in the county.
Could you just ask a quick question?
Natali?
Yeah, will you do some catch-up, though, so, because trending back, since you haven't been able to give that to us, and recognizing some of these cases have take a lengthy period of time to be adjudicated, will you be able to go back and catch up for the last 18 years and to actually have that data and to show it, and then as you mark it each year with the, the more timely input, keep that running tally? Will you be able to do that?
I have inquired by law enforcement as to whether they keep those records, and I've gotten some answers that seem positive, but I'm just not sure how many years we can go back.
So you might go back after 5 or 10, you probably not catch 15 or 18. I just was curious because, again, as you track it, looking, and you've looked at all these cases this team has now for all these many years, it would seem to me if you could get the tally and begin to show whatever those trends are.
Yeah.
Okay, thanks.
Yeah. We are going to make our best efforts to do that. And then thirdly, we noted that and really this goes back to case number 2 that's listed on the cases as they're broken down in the graphs. Just what kind of impact not only does domestic violence have on the abuser, or a domestic violence homicide can have on the abuser or the victim or even their children, but there is a community health problem when it comes to domestic violence that goes beyond just that individual a relationship and family. If you look at the statistics of people that are mass murderers in this country, most of them have a documented history of domestic violence in their family. Most of them have a documented history of strangulation in their family. That was something that I was not aware of until last year. So there's all sorts of trauma that is going on that people are not dealing with, and a lot of it can be connected back to violence that is in somebody's home. I know that my former boss, Jen Scully, used to say that, if you can solve violence in the home, you can solve violence in the community.
Can I ask you a question just to back up a little bit? You said strangulation was the most common form of abuse. Did I understand that correctly?
No, but for people that are mass murderers and people that actually also kill or shoot at police officers, they oftentimes have documented histories of domestic violence and strangulation.
That they perpetrated the strangulation, or they themselves were strangled?
No, they perpetrated strangulation.
What do you make of that?
Well, I believe that the kind of rage that you have to have where you want to put your hands around someone's neck and either try to kill them or communicate to them that you have the power of life and death in your hands is the kind of thing that should be documented and looked at, because those are the kind of people, those kind of rage-filled people are the kind of people that will end up in a crisis situation where they might get into a situation with a police officer and use a gun and use violence.
This means they have a lot more rage than some other perpetrator of domestic violence?
I believe that the new studies about strangulation and what people with these kind of histories of mass shooting or police officer shootings is real. I believe that it's all connected down to the type of rage that's inside the people and what they're willing to do to vent their rage.
Thank you.
Yeah. Okay, so what we are talking about is really doing the things that we've tried to work on so far to try to eliminate this, but to really expand our thought process of how we can deal with children in trauma. As I said, I've been to Camp Hope. I've seen evidence-based trauma applications worked successfully with the children that we've dealt with. Just for those of you that are trained on the ACEs score and trauma, most of the kids that come to Camp Hope have an ACE score between a 4 and a 5. So those are the kids that, when you look at their history, those are the ones that don't have good outcomes in the long run. They're the ones that, you know, live 20 years less of a life and have all sorts of complications and are more likely to end up in the juvenile justice system or the adult justice system. And I would like to actually make as much effort as we can to love them at 9 instead of locking them up at 19. I think if we spend a little bit of extra money at age 9 and show support and love and work on their trauma, we can save a lot of money down the road, and plus we can save a lot of children that are growing up right now to keep them on the wrong path. So we have looked into a number of programs around the country and around California. We're very interested in a program that Dr. Nadine Harris out in San Francisco has created. There was a lot of federal funding that went into it, but I think it's something that we can look at. I've had some personal meetings with county health, county mental health, CPS, some school districts. Everybody seems to be excited about the possibility. So I'm going to be making an effort. I've talked to Anne Marie about this, about maybe having some meetings together and also have some training trauma and some training on their program. Not that we're adopting exactly their program, but something like it, to try to reach kids when they're getting to that school age, you know, that kindergarten, that first grade, way before they hopefully ever get into the CPS system or any system at all. To give them support with the trauma they're going through and to give them support, their family support with the trauma that it often impacts children.
If you could pause for a moment, Bill?
Thank you. On that specific point, I just want to make mention of the fact that this county has recently been awarded a $100,000 grant through HealthNet to do exactly that, to really explore how we can broaden exposure, even training in our various agencies on how to understand and interpret ACE scores. But it's the broader trauma-informed care and service theme that the grant is intended to facilitate in terms of how best to apply that useful tool in local government. And I'm glad to hear that you're sprinkling quite liberally in your presentation the fact that there is so much going on, at least at in the context of the domestic violence report. This type of very useful assessment implement, and would certainly like to have the DA's office front and center alongside some of our other agencies that are just at this point beginning to circle the table and have discussions about how best to apply that initial $100,000 grant, including our probation department as well.
Yeah. I have to say that having the meetings that I've had, working, you know, with the leaders of our agencies, we have a great team in Sacramento. We can get great things done. I think we just need to communicate a little bit better, and then, you know, a little bit of funding wouldn't help or wouldn't hurt either. But everybody seemed to be on the same page. So
good. Thank you.
Yeah. Okay. Were there any questions?
I had another one. I was looking at your statistics in attachment 1. Where the primary language spoken by clients, the number 1 by a huge amount is Russian. I just found, that's page 5. It sounds like most of the clients speak English or Spanish.
Yes.
But
no, that second graph is out of the graph for spoken by clients other than English. So if you look at the graph on top, most of our clients are actually speaking English, but there have been, yes, 21 clients that have come in that have spoken Russian.
so are you focusing additional efforts on that particular community?
We have some really good connections, and when we started the Family Justice Center, we did a real attempt at reach out to that community, which I think has been beneficial in the response. And having people, we have a grant that allows us to have actual translators instead of working with just a language line. So having the actual translators, I think, also helps people. But it really is having the community connections has been very beneficial.
Okay. Any other, Mr. Natoli?
Yeah, thanks. Just on the specific cases, again, these, as you said, these kind of be kind of a dark read when you start getting into the details. But on the case number 6, I guess as you're looking for ways to maybe address some of this, is that you've got a victim and a perpetrator, ages 30, 31, but they had a history going back to 2007, and this is one of those, as you pointed out earlier, where kids were there, obviously involved in the the way the thing played out in the car crash and so forth, and so both the I guess one of them was with the perpetrator at the time, but this one really jumped out the page to me too. Just I guess maybe some mental illness, had suicidal ideation since early as age 6, and was involved with a number of substances, but one that really caught the attention: alcohol, marijuana, a meth 8-ball every day. Again, not that this was known to law enforcement until after this tragic incident occurred. I'm guessing, Paul, just as a team reviewed this and so forth, a lot of it draws back to certainly, maybe some mental illness very early on in the childhood, but by the time he's 30 years old, he's now got a homicide, and as you said, you got kids that are affected by the trauma that goes with all that. One was physically injured. I was curious, any other takeaways? Again, I look at this as somebody reading this chart, and you folks review this, unfortunately, on a regular basis, but is there anything else that maybe could have been done along the way? Because there was 11 years or 10 years in between the time that a first incident when an arrest occurred, and similar situation. I guess there was a crash vehicle there too, when actually some bad things really happened in 2017. So I guess any other takeaways on this? Obviously, this is the chart that you report out, but that one caught my attention.
Yeah. Every single one of these cases is a tragedy, but that one does stick out. And part of it is because the children are present, but part of it is because of the history. And when you see a history like that, you think there are so many opportunities for intervention that could have been positive. So when we look at a case like that, what we're looking at is what kind of contact was there, and when we had that contact, where did we make any inroads at all, or were they successful at all? And really, we found in that one that there was a combination of things that included self-medication on illegal narcotics, along with mental health, but along with rage, where there were some intervention steps attempted, but really nothing that ever sunk in. Nothing that ever really. So
there were some, though, because again, that's not indicated in the chart. So there were some, either with social workers or mental health counselors or referrals to programs. Again, so there was, because that's not self-evident in what you have here.
Right. Yeah, we don't get into those kind of details in the report, but there were 2 or 3 attempts made, if my memory is correct, at intervention that were absolutely rebuffed. And unfortunately, when you have interventions like that aren't forced on you by a court, if the option to say no is no, then there aren't a lot of options for the people that are willing to help. But unfortunately, there were some options available that weren't exercised.
Okay, thanks.
Thank you, Ms. Frost.
Oh, I was just at the Family Justice Center with Jan Scully and Faith Whitmore the other day, and I was really impressed with the program that you have there, and I was particularly impressed with the way you are providing for videos to document situations while it's fresh, and the ability to use that information so someone doesn't have to go over and over talking about what was a very traumatic experience for them. And so I'm really excited about what they're doing over there. And the question I have, and I'm planning to go Friday night, and the question I have relates to these. It seems like in some areas there's more violence, but you're only responding after there's been an incident, an incident. So you're responding after the fact, but do you work at all in conjunction with like our mobile crisis support teams, with your Camp Hope, or do you envision at any point in time that having, expanding to that, working with people who are potentially going in that direction, but they're not there yet? You know what I'm saying? I'm not saying it very well, but prevention versus response and justice through the process after the fact.
Yes. One of the goals from the very beginning of the Family Justice Center was not to replace any agency that's already then, but if we can support and make any agency better, to do that. But the collaboration I believe you're talking about is, the mental health response teams. When we have a potential situation that involves mental health, to have that team go out, I think would be a real advantage. There are going to be times when I think a mental health response is going to get you a much better result than a law enforcement response, or even the combination of law enforcement and a mental health response is going to get you something better than just law enforcement. So we would welcome that, yes. One of the best compliments that I've gotten on the Family Justice Center was from the director of the City of Refuge, which told me that it was her favorite collaboration effort of the Sacramento region, because it's really, when we meet with an organization, we say, how can we make you better, instead of what can you do for us? And having, listening to our partners about what they struggle with and trying to come up with inventive programs that will help, like the Dignity-sponsored mental health program that helps out City of Refuge and Chicks in Crisis and My Sister's House, and now Weave. It's really beneficial to all the organizations that we need to work. Everybody needs to work together. We can't solve this on our own. So it's been
on
helpful.
This map, there seems like there's more in Supervisor Kennedy's. Is this just like a random every year? It's different, and every now and it'll shift. Or
I think if you remember last year, it was an extreme amount in a different supervisors district, and really that is a reflection of the cases that get resolved in court and how many we can actually review. It doesn't mean that there's more domestic violence homicides in Supervisor Kennedy's district last year or anything like it. And that's why I do like giving you the graph, but I'm always worried it's going to, send the wrong message that there's one area in the county where all these are happening, and that's really not true. I'm hoping by having the actual number next year that we're going to be able to get locations and be able to give you a map to show you exactly where they are every year annually in the county.
Thanks.
Thank you. Any further questions? No, Sandy, did you want to introduce the members of your team that are here?
Oh, certainly. We have my former boss and head of our board of the Family Justice Center, Jan Scully. We have our new legal director, Tony Manzanetti. I just looked at one. Joyce Ballou, who is our service director at the Family Justice Center, who does an amazing job. Amazing job. And Jessica is a Weave advocate who's embedded with the Elk Grove Police Department. Oh. And she also does a fantastic job at educating officers about trauma and response and how to deal with victims.
Okay, thank you. Nice to see you again, former District Attorney Scully. I know she likes the former part. All right. So thank you. This is a receive and file for the board.
Okay.
See you.
Thank you.
See you Friday night.
Okay.
Okay. Do you have any other items to come before us?
No, now you're on to county executive comments.
No
County
comment.
executive, Okay. Board members? Mr. Natoli?
Yes, Madam Chair, if I could. I know I've spoken to the county executive, but one of the things, and again, there's no action to be taken today, but it's something I think we didn't consider last week, or maybe it was considered, but when we had the discussion about the Inspector General position, and that relates to the fact that the current contract that was executed in 2015 expires November 30th. We have a hearing set for December 4th to once again take up the matter that we discussed pretty thoroughly over the last couple of sessions and plenty of public interaction. My point, though, today is that in the event that there's some ongoing consideration for the existing incumbent in that position, as well as that contract and the contract terms, then if that expires November 30th, then the point is moot relative to both the incumbent as well as to the current contract. And so I guess the reason I raise that question is I don't know that in the intervening period of time between the time it's set to expire, whether there's delegated authority to the chair and to county executive, obviously the sheriff is involved in that, to do anything that would allow the incumbent to remain, again, recognizing, the situation has gotten us to some of the discussion. So I put that out there because otherwise that clock will expire, and maybe that's known and assumed by all just to be that's the way it is, and we're going to continue discussion about new scope of service and other issues that are related to that. But I wanted to raise the issue. I think it's very important because otherwise, with the board schedule for meeting, we meet again tomorrow, and then obviously have a board retreat on the 13th, which isn't a regular action meeting. And again, if everyone's comfortable with that, recognizing that how we got into it was the existing contract and the existing incumbent and some of the actions that were taken. So I guess I wanted to put it out there, and I don't know, we can certainly have a very general discussion, I assume, without anything else behind that. But I raise that issue because I'm concerned that with all the focus has been put on discussion about the matter itself, the scope of service, the incumbent, and everything that's transpired over the last few months, that if the clock just runs out and we don't do anything, then that is what it is. But I wanted to raise that issue, and so I think it's important recognizing that there are different trains of thought. There's plenty of public interaction. We have something scheduled for December 4th, but when we took the motion last week to suspend, I think that was clear direction to the county executive, to the board's action to do just that. And so I thought it was appropriate at least to raise the issue that if we didn't want the clock to run out on the current contract, recognizing the situation, but also the current incumbent, and any options that might be available to the board on December 4th or thereafter, some of those options go away. And if everybody's comfortable with that, then fine. But I have some level of discomfort with that in the sense that as we're trying to work through the issue. And so I wanted to raise that because otherwise it just happens, and come November 30th, that door closes. So that's why I put that out there, Madam Chair. And again, I don't know how people feel about that, but I think it felt very important to raise that.
Mr. Cerna?
Thank you. I appreciate Supervisor Natoli's concern in underscoring the date sensitivity of the existing contract and the fact that this board acted the way it did last week, requesting of the County Counsel's Office and CEO's Office to come back on December 4th with a broader discussion about a wider breadth of options for this board to consider in terms of the future of the IG and what authority the board currently has or may want to consider amending in terms of the ability for the IG to enjoy unobstructed access to what he or she needs to do to perform their duties. I guess I look at it a little differently, and certainly when I made the motion last week that was supported by this board to move forward, I did it with eyes wide open, understanding fully that the month of November held for this board otherwise an opportunity to reconsider the contract, keep the incumbent IG in place. However, correct me if I'm wrong, either county counsel's office or the CEO's office, but if the contract were to lapse, and in the meantime, this board acts as swiftly as it can to have a fuller discussion about options, I don't know that there's anything that necessarily limits the ability of the board, again, based on its will, not predetermining anything, to reconsider the incumbent, perhaps with a much stronger set of parameters, such that he can do exactly that, perform his job unobstructed. That was the spirit that the motion was made in, and certainly with that full understanding.
Phil, I know that you folks were weighing. But my understanding is I've asked a question about whether if the current contract expires, whether we have the latitude, and again, I haven't seen any legal advice on it, but what's been channeled back to me through my question has been that when it's over, it's over. You got to go out to an RFP. Now, if that's not the case, if we have those options based upon what you said and what we might deliberate on December 4th, then that's, I certainly would have a higher level of confidence, but that's not what I was getting back. And so I think to your question, I'd like to hear from Nav or Robin, recognizing, I don't want to go too deep here, but if in fact, that's what happens, that we don't have that option, irrespective.
But my point is, Don, is that even if we have to go out to an RFP, there's nothing that keeps the current Inspector General from competing in that RFP and this board from reselecting the existing incumbent.
That's true.
Supervisor, certainly you are correct that if, as the contract is lapsing and the board's desire on the 4th is to go back out, nothing precludes from the existing OIG from being in that process.
Yeah, and remember too, the one party we really haven't heard from is the current IG himself. Who knows whether or not the current IG would even want to consider, putting his hat back in the ring, assuming that there was a lapse in the current contract, assuming that we did go back out with an RFP. Maybe he is interested, maybe he isn't, I don't know. But
that would be decided if he just wanted to respond to the RFP. I mean,
correct.
You would know then.
Exactly.
And the problem I have with that, Don, is an RFP, we'd all have to agree on the scope, I think, and then you put it out, and then we're in May. It's just, or maybe April, I'm not sure, but
if I could just offer one other thought, and again, certainly, Robin, if we get too far with the conversation, but I just wanted to offer a thought, and again, it's all within the time frame with the clock running, and that we have, there's a current contract, and again, is certainly Supervisor Cerna, the chair of that year, and the sheriff at the time, and recognizing all that has transpired, but those were agreed upon terms. We renewed that in 2017. We'd have the ability, again, assuming that there was a willingness or interest by the IG, who's our IG, up and through November 30th, and there was under the terms of that contract, recognizing that we've spent a lot of time and we'll spend more time talking about new scope of service terms, what got us to where we are and where we want to go. But I guess that lapse of several months. I mean, if the contract was for whatever downside it has, had some weaknesses, but if that was kind of what got us here, we're going to have plenty of time to talk about that, because we were talking about going for another scope of service at some point in time anyway, whatever that is, broader or narrower, or something in between. It seemed to me that we had a contract, and there was and if that could be at least be extended for intervening period of time while we have this ongoing discussion, the public dialogue that's very important to all of this, and get our feedback to at least bridge that over. And if not, if there's not, then we'll go without. And yet I think that, it's, for a couple months, maybe that's not so critical, but I can still, to your point, Susan, I can see that it will be some time. And that may be entirely appropriate for where we're at, but I am concerned for that lapse. And if you could, I don't know if we could delegate authority, if we had an item where we could delegate authority to the board chair, to extend the contract for 30 days or 60 days to give us some time to continue to work on this, so we're not bare during that period of time. But maybe that's not big enough concern. So I may have gone too far in my discussion, Madam Council, but to me, this is, it's important, and I guess we could agendize it to at least have that conversation about what happens between now and whenever.
We'd have to agendize it for tomorrow. Ms. Frost?
I don't think we can have, I don't think it makes sense to extend a contract that the sheriff is not willing to work with. We had a contract that the sheriff was willing to work with, and we were not able to agree upon that. And so I don't know if it makes sense to extend a contract where we're paying someone to not be able to do their job. So I'm just wondering if, I think the sheriff needs to be a part of that entire conversation.
So what we're talking about is the difference between the contract we currently have and the one we had under discussion last week? Don, is that the essential difference you're talking about?
Yeah, I hadn't really gone there. I just, with the existing contract, we have one, we know where we're at with that. There was discussion last week about resumption of duties, but that was under a new scenario. And so that would have been under a new scope of services. We heard very clearly from a number of the folks in the audience what they thought about that. But the existing contract, I don't necessarily think people saw as being having any fatal flaws. Obviously, there were, what transpired, again, without getting too deep into it, brings us to where we're at. But, if there was an interest in, utilizing the existing contract with the existing incumbent and to resume, the functions of the IG under that scope of work, which would the independent oversight and so forth, recognizing that does require the concurrence of the sheriff under that existing contract. And if that's not sufficient, then, to the point being made by Supervisor Frost, because from the standpoint of the scope of services, we're going to continue to have that discussion. We're going to have it on the 4th and maybe, thereafter. But we know there was a contract that's currently in place that's still a valid contract. That, again, if there's a willingness and a desire to resume, recognizing, what got us to where we're at, but to open the doors, to have access again and so forth, and then we work through the other aspects of this. But
Or we adopt the addendum or the new scope until, and for 1 year while we discuss any potential changes that we might want to have to that. Then we have somebody in place.
So at the moment, our unagendized discussion is over something that is currently scheduled for December 4th.
Right.
And there was unanimous vote contemplating a contract that's end date was November 30th to schedule a discussion for next steps on ending November 30th for discussion for December 4th. So on December 4th, as currently scheduled, we could include in that temporary measures such as the chair is proposing to seek out. We could have the parties discuss whether there's mutual agreement possible for a short-term continuation of that contract. That can be part of what the discussion is on the 4th as the direction given for what's in the toolkit for the board to enforce actions with the sheriff. If something other than that is contemplated, staff is here for direction if you want a different discussion on November 30th, but at this point, that contract is coming to its natural end.
what's the continuation, though? I just need to know that then. So we're going to be back in 3 days after it expires. And if we got to the point you just described, or working through with all the input we're going to get, we could actually continue the contract.
It wouldn't be continued, but it could be a new contract on similar terms or shorter terms instead of a 4-year term as proposed. It could be a.
But do you require to go to RFP? I guess do you have to go out to that whole, or are you able to do something in the intervening period of time if the board gave direction? Do we have that latitude? I guess to answer that question.
We could have We could certainly talk about interim measures, some kind of short-term solution if you want, if the pleasure of the board is to seek a full review with RFP who's out there. And again, we don't know if the other side of that
Right.
contract is willing.
I think you're
But we
beginning to
could do
violate
it.
your own warning.
I know. So again, if you want something calendared sooner than December 4th, we could certainly put something on November 30th.
May I ask why we couldn't do it tomorrow if we're reconsidering the motion and due to the urgent nature of the situation of the contract expiring, and I think in the heat of the moment that maybe we all didn't realize that we were going past the term of the expiry of the contract.
How do you do it without a 72-hour notice?
I think under an urgency reconsideration, you're okay on that.
Whether this is in fact an urgency or an oversight, the 30th might be more prudent just in terms of the 72-hour noticing. The contract will certainly be in place between tomorrow and the 30th.
Ms. Frost?
Do we even know if the IG wants to continue? Because in my conversation with him, I had the impression he was done with the county.
Well, I personally, I don't think that's, because I'm interested in moving ahead with the new contract. I don't know that that's relevant.
He has never said anything, so we don't know.
Well, he might not be willing to enter into the argument.
I think we're treading on
Yeah.
very thin ice here.
Yeah, I don't think we can even have the
We
conversation.
could bring this back on the 30th with an answer to that question.
How are you going to ask him when you don't have we don't have a contract?
I guess what the question is that we don't have a date, we don't have a board date for November 30th. I think, Robin, what you're
Oh,
getting
okay.
at
Yeah.
is, does the board want to have a meeting on November 30th and agendize with the 72 hours and everything that county council just said?
I think we should just meet on December 4.
But the point Mr. Natoli is making is then that the contract is finished on November 30th, and the contract is out of date and over with, and so we'd be starting a whole new process, which, when you go out for an RFP, whether the current Inspector General applies for it or not, it's going to be several months. So we wouldn't have an IG till, like I said, I'm going to say April or May, something like that.
We can't, without having that conversation with the sheriff, we're basically hiring an IG who's limited on what he can do. So it seems like the sheriff has to be part of the conversation.
Oh, of course, of course.
My suggestion would be, we have an item for December 4th. We do have a retreat on the 13th. Why don't you let me look at this tomorrow and bring to you on the 13th some suggestions?
The 13th of what?
November.
Next
November,
week.
we have a board retreat.
Oh, the board retreat. Oh.
Between now and the board retreat, if there's
Why
something.
can't you bring it tomorrow?
It's not the type of an urgency that would warrant an emergency agenda item, just because it's been before you with that expiration date. But staff can work together for some kind of, if we need to agendize something on the 13th, we certainly could. We'd work with the chair on that.
I don't know that I want to get this issue on the board retreat agenda.
Okay. All right.
So,
We are where we are, I guess. I guess if, just a final comment, that you could at least lay out what information, what options might be available. I mean, if there's anything different that beyond what you're able to respond to today because of where we are with comments, but that would be helpful. I mean, again, we have the ability to come into session if we chose to, if that was what we wanted to do, but I don't sense there's, any consensus around that, so that's all I had.
Could we schedule a meeting 72 hours from now? I mean, Friday or something?
We've never had this much discussion
Well,
about
she's
an
the
item
county
that's not,
counsel,
that's
I'm not
not
an
on the
attorney.
agenda ever.
Okay, so, fine.
Oh, it looks like we have 4 different opinions here.
About an issue that's not on this agenda.
Well, she's allowing the discussion.
Well, and I'm looking at her to cancel, to
I get
interject and do your job and tell us not to talk into the
I
10th
get that.
minute
I'm just
about
trying
an
to
item
give the
that's
chair's
not on the
some
agenda.
solutions. Let me come to the board meeting tomorrow with
The agenda.
right, we don't have it on the agenda, so
I think we should just meet in December.
That's fine.
let me work with the chair on what possible choices there are for putting something on the agenda at an opportune time, whether it's 72 hours from today or whether it's some other available date in November.
Okay, so what we're just talking about is finding a date, if possible, before the end of November.
If that's your request, yes.
Okay, nobody's looking at me, so I don't know if that's,
I'm just weighing,
what'd you say, Don?
no, I was just weighing out what was being said here. I just,
Okay. Bring something tomorrow.
Or what?
For possible meeting dates.
I don't think it's appropriate to have the conversation without the sheriff, and so I don't support extending the existing contract since we know we're going to be paying him to do a job that he can't really do. It doesn't seem like a proper use of taxpayer funds, taxpayer dollars.
Well,
I'll move to adjourn.
well. So if we're going to adjourn, then we're coming back on December 4th on this issue.
right.
Okay? It is adjourned.